Welcome to the Rob Call Bottom Up Show. It's available on Pacifica Radio Network, on Progressive Radio Network, on iTunes and Stitcher and SoundCloud, and at opednews.com/podcast, where the complete record of all the interviews are. My guest for the show is a multi-time repeat guest, Paul Hetznecker. He is a defense attorney, a radical lawyer and defense attorney who represents protesters, hundreds, maybe even thousands of them. He's the president of the board of the Defenders Association of Philadelphia. He's an adjunct professor in sociology and anthropology in criminal justice department at Arcadia University. And his website is Paul J. Hetznecker.com. That's Hetznecker. Hetznecker. Great to have you back, Paul.
Great to be here, Rob. Thanks for having me once again.
No, it's a pleasure. And you know, it's a different question here. Usually I talk to you about how you're defending protesters, but here I saw what happened last week with the attack on the Capitol, and I thought, who's going to defend those guys? What will they be defended for? How would they be defended? And I just got curious right away. What's your take on what's happening there and what's going to happen to them?
Well, it's hard to answer the question directly without giving some historical background. There has long been an allegiance between law enforcement and right-wing nationalist, white supremacist organizations in this country. And that goes back to the history of policing, from the slave patrols to the efforts with the first historic police department, emergence of the first police department in New York City. It was essentially a force and an arm of the government to maintain status quo. And that status quo, as we all know, Rob, was a racist class and caste system. So without analyzing the class structure and the power structure of this country and the racist nature of the origins of policing and law enforcement, it's hard to talk about what happened last week in a vacuum. So typically, as you well know, if a progressive movement decides to engage in protest activity at the Capitol in Washington, D.C., and you've been to many, I'm sure, and I have as well, there is a extreme show of force by law enforcement every single time. And there's been a history of that. So when it involves a racial social justice movement, a progressive political movement, law enforcement comes out in droves in a show of force, despite the fact that those protests are peaceful. Here we had an inversion of that. We had a very motivated mob activity on the part of right-wing white supremacist protesters, egged on by the President of the United States and other politicians, to, quote, storm the Capitol with little or no resistance. And with all due respect to those Capitol Police that were injured, and they certainly tried to resist, there was no attempt by the upper echelons of law enforcement to provide any kind of protection barrier around the Capitol. So, for example, when I represented the Democratic National Convention protesters who were arrested for breaching the security fence that was built a quarter mile, that 9-foot fence that they have now around the Capitol, that was a quarter mile from the Wells Fargo Center in Philadelphia, which was the site of the Democratic National Convention in 2016. Some of the protesters breached the fence. They were immediately arrested. There was a huge, huge contingent of law enforcement, multiple agencies, Philadelphia Police, State Police, Federal Secret Service, and other agencies. And that fence that was a quarter mile from the site of the convention. Here, we had no such fence. We had no such barriers. And we have now reports by independent news organizations that there was complicity by many members of Congress and or law enforcement agents and law enforcement officials on the ground with the protesters in allowing them into the Capitol. That reflects and is a manifestation of a long-standing allegiance, as I said earlier, between law enforcement and right-wing white supremacist organizations in this country. And it goes way back to the origins of policing, the slave patrols, and the effort to maintain a status quo of a racial caste system, of a class system that protects those in power, and is antithetical to the modern notion of protecting our Constitution under the Equal Protection Clause in a way that protects everyone's rights to protest, but doesn't allow for the actions of some because of an ideological allegiance between law enforcement and right-wing organizations to violate the law at will with the permission or with the acquiescence. I shouldn't say the permission, with the acquiescence of law enforcement. And that goes, there's a long history to that where the FBI may track right-wing organizations, but there's no database to connect those organizations with law enforcement. There's no, that's shared with the rest of the public or shared with other law enforcement agencies. So we've had instances throughout this country where there have been very public reports of allegiances between white supremacist organizations and various police departments. And the FBI is well aware of it. The FBI has tracked this, but the FBI doesn't create a database that's available to the public and track the relationship between individual officers, departments, and white supremacist organizations. And so it's not surprising that now there's a call for that. Well, that was actually a call by the Democrats last year when there was a report in a military journal that there was widespread belief among military members that there were white supremacists embedded in the military and the armed services. And there were calls by various members of Congress to investigate that as a part of the Armed Services Committee. And an investigation has begun, but there is very little support by the Republican Party in doing so. So we have an ideological basis, an allegiance between law enforcement and right-wing and white supremacist organizations. And what we have last week is obviously a combination of First Amendment protected activity and then violent actions on the part of a small group of individuals, or you want to characterize it large or small. I say it's small in the context of the millions that have gone to protest the Iraq War, the millions that have gone to protest in support of Black Lives Matter. So a small contingent of right-wing individuals who violated the law, broke into the Capitol, and have stirred discussions about what I've just mentioned, the history of this allegiance, but also what's protected under the First Amendment and what isn't.
Would you defend these people?
No. As I said before on your show, I defend everyone's First Amendment rights to express their point of view. And as I've said throughout my entire career, individuals should have the right to express their First Amendment rights, regardless of their political point of view. And that First Amendment right shouldn't be infringed upon by the government, but should be met forcefully in terms of voice and marches and demonstrations, should be met with opposition. So if you have, the Nazis in Skokie, Illinois, or if you have the Klan in some particular location, there should be a strong counter protest expressing the opposite point of view under the First Amendment. So I would not choose to represent right-wing fascists or white supremacists in protecting their First Amendment rights. I believe that they have the right to express their point of view, but they also have the right to be shouted down by a counter protest, which we've seen throughout the summer. There were many small groups of right-wing white supremacists met by larger groups of coalitions of social justice activists who shouted them down on the street. And that's essentially the cauldron of our democracy, is that battle over ideas and points of view without violence. In this particular case, as I said, I support everyone's right to express their First Amendment rights, but I choose, as I said before on your show, I choose to represent those that I am ideologically aligned with, and that's the progressive left and social justice movements in this country, and I've committed myself throughout my career to do so.
Who's going to represent these people who invaded the Capitol?
That's a great question. I'm sure there are plenty of attorneys that would step forward that represent these organizations or represent many of the organizations that were reflected in the mobs, members who were reflected in the mobs or part of the mobs that were there in Washington last week. So I'm sure there are lawyers that will do so. And then there are, of course, public defenders. Many of those people will be represented by court-appointed lawyers, appointed by the court to represent them. And that is what I've done throughout my career, is also been a court-appointed lawyer. But at this point in my career, I would choose not to represent someone who represents a fascist movement, someone who represents ideas that are antithetical to my moral beliefs and political beliefs, and that's my choice. But I certainly laud the effort on any defense attorney to represent their client zealously, regardless of what they're charged with, which is what I've done as a criminal defense attorney throughout my career.
But so you're saying that you need both sides to be protesting. That's good. My opinion is anybody that stands up and protests against the Trumpsters, they're labeled as Antifa generally. They don't
That's correct.
People the benefit of the doubt or the respect that they're protesting for a different position. But are there, I mean, if you're on the left and you're protesting, you've got a bunch of lawyers wearing green hats, usually, who are legal defense when there are major protests. And I don't think, I've never seen you wear one of those hats, but you're in the background waiting to do the defense.
Well, let me explain that part. That's a good point that I want to clarify. First of all, on your previous point, yes. So we've known law enforcement to demonize the left and to cast broad strokes about the nature of leftist protest and dissent in this country. They have labeled the Black Lives Matter movement, that is the FBI and Homeland Security, has labeled the Black Lives Matter peaceful protest movement a national security threat. The potential terrorist organization in 2015. That's a reflection of the right-wing paradigm that's embedded in law enforcement and has been for decades. So the law enforcement views of the left go way back to the early days of class struggle in this country, when Pinkertons were used, when law enforcement was used to fight against the labor movement, to demonize and criminalize syndicates and unions in an effort to struggle against the power of the capitalists and the inequities, the inherent inequities in a capitalist system that reflected in a movement that went on and a struggle that went on for 60 years and still goes on, but went on principally without legislation protecting the rights of workers for 60 years. We had the same thing in the civil rights movement. We have embedded in our system in late 1950s, 38 states had Jim Crow laws on the books that were enforceable by those states. So we had a system, a criminal justice system, and a law and a legal system that was embedded in the racist caste system that we find our origins of which are in slavery for 400 years. So to talk about the ideological reflection of that in modern day is important to link it to the history of the way in which leftist organizations, groups that had challenged the status quo, groups that had sought racial justice and social justice in this country and equality, were demonized by law enforcement as a part of the power structure's effort to quell dissent, to quell the class struggle, to quell the civil rights movement, to quell the labor movement. So we have that embedded, that same ideology, that right-wing ideology has extended throughout the history of our country. And so we have law enforcement, the FBI, looking upon the Black Lives Matter movement when there's 27 million people that marched in the streets of this country in a period of about a week as a threat to national security, as opposed to a peaceful protest movement seeking social change. Whereas we've had serious connections between law enforcement that has been documented by the Southern Poverty Law Center, by the Brennan Center, by the ACLU, serious connections and allegiances between white supremacist organizations, right-wing militias, and law enforcement. And the FBI has allowed it to flourish. So that's the answer to the first part of your statement. Now, with respect to protests themselves, what I think you're talking about with the green hats, they are legal observers. So legal observers can be anybody. They're trained, oftentimes by the National Lawyers Guild, which is an organization that has long protected the rights of protesters, as well as the rights of those who have been downtrodden by the system. And they're trained as legal observers, oftentimes law students, which I was a legal observer. Back then, we wore yellow bands with black lettering that said legal observer on our arms. National Lawyers, NLG, legal observer on our arms. It was a yellow band with black writing. Now there are green hats or green shirts, which clearly demarcate who they are, and that they're there to observe and protect the First Amendment rights of the protesters, to mark down if there's police misconduct, to record it, to mark down if people are injured and make sure they get assistance, medical assistance, and then eventually to testify, possibly as witnesses to the events that occur where police violate people's rights on the street. So I have been protester, I have been legal observer, and for my entire career as a lawyer, I have been protecting the rights in court of social justice movements and protesters who have been charged with criminal offenses.
So are there comparable people and groups on the right?
Not that I'm aware of, not in the same way. No, not that I'm aware of. Because again, I think part of this goes to the history of the allegiance between police, how police identify with right-wing militias. I'll give you an example, and I'll go back to the case.
But basically what you're saying is on the right, what they have is a wink
Exactly.
nod to the police that everything's cool. We're going to do what we want, and you're going to let us because you're on our side.
And I'll give you two reflections of that, two manifestations of that. One is about 10 years ago in Philadelphia, there was a website that was uncovered that was titled, it was a group of police officers. It was a kind of a website and a blog, a blue by day, white by night. And essentially it was a bunch of racist white supremacist police officers who would espouse their views on this website, their racist views on this website. Eventually the website was shut down, but those officers, and one or two may have been disciplined, but there was no uprooting or vetting of those officers or eliminating and firing those officers from the department. And I'll go to that, my point about this vetting process in a moment. There's another example more recently. So two examples. One during the George Floyd Black Lives Matter protests in Philadelphia, where a group of a white mob attacked Black Lives Matter protesters, a small group of neighbors, and not just protesters, just neighbors in a community, in a reaction from their reactionary right-wing white supremacist point of view in a neighborhood in Philadelphia, and beat up Black Lives Matter protesters, and the police did nothing. They stood by and watched. And that particular event is under investigation right now, as well as subject of a lawsuit. A third example this past year is was widely reported in the news in Philadelphia, was the Fraternal Order of Police event in which the Proud Boys showed up and participated in this social event with the police union. The police union came out and denounced it, saying that they were not aware of that. But it's hard to believe or hard to imagine that, given the posts that were reportedly on right-wing media, that the FOP was not aware in advance that these right-wing extremists were not present or weren't welcomed as a part of this event. So those are three examples of this allegiance. And I think it goes back to what I wanted to say earlier, which is there's no vetting in police departments throughout this country. If you're to uphold the Constitution, if you take an oath to uphold the Constitution, that doesn't mean the Constitution of Jefferson and Washington, who were slave owners. That means the Constitution of our present day modern life. And that means the Equal Protection Clause applies and the anti-discrimination laws apply.
So what you're saying is there's no vetting of police to determine whether they're white nationalists or not.
Correct. Just like there's no vetting of military recruits of whether they're white nationalists.
So there's the Oath Keepers. The Oath Keepers are police and military who promise to stand up for their rights of, I don't know, the Führer, the whatever. And, there were people there at the Capitol wearing Oath Keepers regalia, hats and what have you. Oath Keepers are police, are often members of the police, right?
Right.
Do you think that they should not be allowed to be police?
Absolutely not be allowed to be police. Your job should be contingent on your ability to equally enforce the law, and that means respecting the notion that everybody in our society should be treated equally under the law. And so, if you hold a racist view, you're ineligible to be a police officer. You can't uphold the Constitution as we understand it today. And the First Amendment isn't undermined because it's a job. It's a job. And as the Supreme Court has said, that the right of public employees, although important, First Amendment rights are important with respect to the expressions about their job, there's no automatic right to have a white racist neo-Nazi on the police department that's essentially going to undermine the rights of African American and Latinx citizens because of their view. They're not eligible to serve. So being a police officer is not a right, it's a privilege. Being a military officer or a representative of the military is not a right, it's a privilege. And if you do not believe in upholding the Constitution as applied equally to all citizens of this country or to all residents of this country, then you have no right to hold the position. And what's unfortunate is there's no vetting of that for police recruits or military recruits. It's not asked. It's not a part of the process. There is some tracking recently. There's some tracking by the military to conduct some tracking of a white supremacist organization, but tracking doesn't do anything if you're not going to enforce the Constitution as we understand the Constitution will apply to everybody. And if you hold, it's not as if you can hold a white racist view and stand next to an African American officer and expect that white racist military recruit is going to abide by the edicts or the directives of an officer because he's black. That's insane. That would be antithetical to every notion of equality. That officer, that recruit is not acceptable and should not be a part of the military. Yet we know that many of these right-wing militia and white supremacist organizations are encouraging their members to enter the military, to get military training. And we know that from the Southern Poverty Law Center. We know that from the Brennan Center. We know that from the ACLU. We know that from a lot of organizations that are tracking these white militia, neo-Nazi militia and white supremacist groups. So there's long been a history, as I've said, between law enforcement, the military, and white supremacy, and we need to eradicate it from those institutions.
We need to take a quick show ID break, and then when we come back, we're going to talk about how you think these people can get any defense at all, or if they're defensible. So we'll pause for 20 seconds, and then we'll start up again. And my guest for this show is Paul Hetznecker. He's a radical defense attorney, lawyer. He is the president of the board of the Defenders Association of Philadelphia, and he is an adjunct professor in sociology and anthropology at the Criminal Justice Department of Arcadia University, and his website is pauljhetznecker.com. So what's going to happen with these people? You got the FBI investigating several hundred people. They've already arrested apparently about 100. What's going to happen to them? Who's going to defend them? What will their defenses be? Do they have legitimate defenses? And what kind of risks are they exposed to in terms of jail, other punishment, fines? And how does that compare to people who are on the left who protest?
Well, it's a complicated. First of all, everyone has a right to a defense. As a criminal justice professor, but also more importantly, as a criminal defense attorney for the last 34 years, I strongly believe in the right under our Constitution to the Sixth Amendment, which provides for the right to effective assistance of counsel. And I think, any attempt to undermine those rights would be antithetical to our Constitution. So everybody charged with a criminal offense has a right to a defense. And that defense should be predicated on an analysis of the actions of those individuals charged, against the statutes with which they are charged, the crimes with which they are charged. So my understanding, I haven't done a deep dive into any of the cases, but from my understanding, most of the people who have been charged so far are charged with criminal trespass or trespassing on a federal property and destruction of property. Those would be considered lesser offenses than felonies. There are considered minor or misdemeanor offenses under federal law. My understanding is those are many of the offenses that have been charged. And there's certainly many defenses that one could raise with respect to the property itself, but I'm not here to defend them, nor am I here to foster a defense for them. Their attorneys will do so. And those attorneys, I'm sure, will do a great job in doing so, as I expect every lawyer representing a client, whether that client is a rapist, a murderer, a mass murderer, someone who is a pariah from the view of society. That person has the right to a defense. And so those lawyers that are charged with defending those individuals will do so ethically and they'll do so zealously, as I expect any lawyer to do under the Constitution.
Yeah, but well, how will they defend them? How would, if you, I mean, if you were defending that, you don't want to get into it?
No, I don't, frankly, Rob, because it's not my job at this point to provide a strategy publicly to those who are antithetical to my political point of view. So, as I said, every defense starts with analyzing the statute, looking at the statute, the crimes that are charged against your individual client, and seeing whether or not the actual facts against your client are met by the elements of the statute. And if they're not, then you have a built-in defense.
Do you
And
think
so
most of these people who are getting arrested are going to end up spending time in jail?
I don't think that's the case because they're misdemeanors. I think that most of them will not spend time in jail. My expectation is many of them will be given probation and or fines. It depends upon, again, the nature of what they're charged with. So those that are involved with destruction of property will probably face jail time much more readily. You know, there's a system in the federal system. There's a guideline, sentencing guideline structure, and that sentencing guidelines determines, based on a matrix of the offense conduct versus prior record, where you fall within a guideline, where each individual falls within a guideline range, that range of months of incarceration and or no incarceration. So most misdemeanors with no prior record wouldn't call for a jail sentence. But that doesn't mean people shouldn't be charged, and that doesn't, as I said, it doesn't mean people shouldn't be defended. This is part and parcel of the adversarial system. So I want to make a comment about this because I think it's important to note. People might say, well, that's a contradiction. You're not willing to defend right-wing activists, yet you defend left-wing activists. No, but I've defended murderers. I've defended people who were charged with very serious sexual offenses, rape. I've defended child sex offenders. I've defended people who were charged with multiple murders and people who were considered hitmen. I've done all of that because I believe very strongly in the protection under the Constitution of the right to a defense, of right to an effective defense. And that means that providing in our adversarial system a check on government power, regardless of where that power is coming from and regardless of when that power is exercised, we as defense attorneys stand, in the words of Charles Ogletree, and I repeat this mantra often, as the last sentinels of the Constitution. So that if that power by the government is overextended, even with respect to right-wing activists, if they've overextended and they've charged the wrong people, those cases should be dismissed. If they've charged the people if they've overcharged individuals, then those charges that don't apply should be dismissed. But it's important to realize that the actions of a criminal defense attorney, the context of a criminal charge, is the fulcrum of our democracy, because that's where the power of the government meets the liberty interests of an individual. So no one should ever be charged for expressing their First Amendment rights. I don't care what they're expressing, whether it's a right-wing view, antithetical to the very principles of equality in our society, or if it's a progressive point of view, obviously. No one should be charged for expression of their First Amendment rights.
But the reality is most people who are charged in today, there's no attorney that defends them in court. They usually, the attorney represents them in a negotiated settlement. They avoid the jury trial because of the cost of it.
Well, that's a great question. There's a much more sophisticated deep dive analysis of this. So in the context of the criminal, well, no, it's important. I think the public understand two things. One is there's been a lot of blurring of lines in the media about what's criminal and what isn't. And I think there's a huge mistake on the part of media to characterize peaceful protesters that showed up in Washington just to express their point of view, even if as ill-conceived and as naive and ignorant and racist as it might be, as being criminal, as blurring the lines, to those who actually committed criminal offenses. And that shouldn't happen, number one. Number two, in our criminal justice system, we have a assembly line. There's no question about that. And I call it the assembly line of injustice because under our notion of the social contract, where we are empowered with the protections, the procedural protections that are provided in our criminal justice system, the right to a preliminary hearing, the right to force the government to produce evidence against you, the right to look at that evidence and investigate that evidence, the right to file motions to suppress, the right to file motions to dismiss. All those rights are not exercised by anyone but the criminal defense attorney. It's not exercised by the prosecutor. It's not exercised by the judge. So in order to allow for the full panoply of criminal justice, criminal procedural rights to happen, you need a strong criminal defense attorney to do so.
Yeah,
to
but
exercise
the
those
problem
rights.
is,
But wait, let me,
is that what is it? 98%.
yes. So I was going to get to that.
Are pled out because
Yes.
the defense attorney never really gets to do hardly any of that stuff.
Well, let me defend the defense attorney on this, Rob, because I think the public's
I'm
view
not
is
criticizing the defense attorney. I'm
no,
criticizing the system.
you're the system, and I agree with you on
They
the system.
bully the defendants into saying, I'll accept a deal because I can't take the risk of going to a jury trial where I'll be punished much worse.
Correct. You're absolutely correct about that. So there is unfortunately, built into the process of this assembly line of injustice, as I call it, this key component to the expansion of mass incarceration in this country is just as you say, which is this, that if you exercise your constitutional right to a jury trial, you do get punished much more severely, generally, than you would if you pled guilty. The incentive for people to plead guilty is just that. It's built into the negotiating process. So yes, does that undermine our system of justice? Absolutely it does. And I've been railing against that my entire career. But I've also participated in it because in the existing system, in order to ensure that that individual in the existing paradigm gets the benefit, for example, in the federal system, of 3 points for acceptance of responsibility. Well, 3 levels down in the sentencing grid could be significant. Gets the benefit of what we call mitigation, recognition of mitigation by pleading guilty. That's a mitigating factor under most state sentencing guidelines. So yes, it's always a struggle. It's a difficult moral and ethical and political struggle that goes on all the time in our system between what's the reality of the crime being charged and what happened, and what's being foisted upon the criminal defendant charged with these offenses and how to grapple with it. So it's a minefield. There's no question about it. If we go to trial and we lose, you face a mandatory sentence of 20 years. If you take the offer, you might get a guideline range of 6 or 7 years. These are the issues that criminal defense attorneys and their clients have to grapple with all the time. So you're absolutely correct on that point. Within the system itself, as a technician of the system, as a criminal defense attorney, we waive those rights under the social contract in exchange for a more beneficial sentence, for a more beneficial deal. We do that all the time. You're right, 98% of the cases don't go to trial. And so the problem with that is you could have cases where there's extreme police misconduct and the prosecutor may know it or have a hint of it. The police officer certainly knows it and may whisper in the ear of the prosecutor and say, cut this guy a deal. And so what occurred on the street often isn't revealed because the sweetheart deal is offered. And yes, people who are incarcerated because of high bail, because of bail they can't afford because they're poor, end up in jail and taking deals because they want to get out of jail far often than they would if they had been on bail in the first place. So yes, the entire system needs to be revamped. When we talk about criminal justice reform, we talk about dismantling a process, an assembly line that has been geared towards mass incarceration for decades. We need alternatives to the criminal justice system for social ills that have been foisted and economic ills that have been foisted upon the criminal justice system that we're ill-equipped to handle.
What are we going to learn out of this Capitol riot? Any lessons that are going to come out of it? Any surprises in terms of how it's going to be handled by the courts? What do you think?
Well, that's a great question. I think it depends upon where we are in terms of investigation by Congress into the allegiance between those in the hierarchy of law enforcement that allowed this to happen, because that clearly the evidence is there. There needs to be investigation with respect to that. So hopefully we'll learn a lot about and think a lot about as a society about the allegiance between law enforcement and right-wing militias and just even if there isn't a direct connection, the ideological identification with those organizations by law enforcement, even if they're not members of it, the identification, the ideological belief that they are us in some fashion as opposed to the other. Yes, I think we'll learn a lot about more about policing in America as a culture. Now,
so what you're saying is we're going to learn in greater painful detail about how the police dropped the ball, didn't do their job, and let these people perpetrate crimes of different levels because they were white and because they were white supremacists.
Correct.
So
So this becomes one chapter in many, 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 many chapters of this in American history. But maybe it becomes a chapter which starts a clear and open dialogue nationwide over policing in this country based on the historical roots of white supremacists and police
but you were
police
just
departments.
describing how sometimes police might whisper to a district attorney, cut this guy some slack because we misbehaved.
Well, they wouldn't say we misbehaved. They'd say cut this guy some slack.
Okay.
So in
But-
other words,
but I'm just wondering, how would that apply in the Capitol riots? How would the police influence the outcome of some of the prosecutions there?
that's a great question, Rob. That's a really good question because we don't know right now as we sit here, we don't know if there was any conspiracy between members of Congress, which have certainly been talked about in the media over the last few days, and some of the people that are now believed to be organizers, although that's not clear either. But these are all subject to investigation. So we don't know what the conspiratorial connections are. But beyond the conspiracy, so I think that there's going to be an investigation to see if there is a conspiracy between law enforcement, a wink and a nod, or looking the other way, or we don't need to call in. We've heard, it was the most widely publicized mass gathering in recent of right-wing activists in recent years in Washington, and yet law enforcement response was interestingly completely nonplussed. There was no buildup of law enforcement. There was no show of protection of federal buildings. So to watch from afar and see that happen, it doesn't take much to say that there's an identification with the right-wing supremacists in a way in which law enforcement in this country does not identify with the Black Lives Matter.
Could be worse than that. I mean, it could be that, there were orders to stand down or stand back. When it came to the governor of Maryland trying to bring in troops, he was not able to because he couldn't get permission. I mean, so it could have been that Trump was behind this, or Trump's appointees were behind it, keeping people back.
Right. You're absolutely right. And all you have to do is look at the orders that were issued last summer by the White House with respect to the peaceful protesters that were out in front of the White House and the way in which they were brutalized, and look to see what the communications were between not just, Trump, but many in the White House to, for example, the Defense Department, when the head of the Capitol Police called the Defense Department and said, we need help, we need reinforcements. Allegedly, he called and made that call. And we'll see whether that's true or not. And I'm not doubting that there were calls made, but maybe a little too late, and who knows. But certainly there were no reinforcements being sent for hours and hours and hours. Yeah. So yes, I think you're right about that. And then again, I think that's what's going to be revelatory with respect to the investigation. But what I'm hoping more importantly is not just this as a flashpoint, but a much deeper look into the long-standing allegiance in this country between law enforcement and white supremacist groups, not just directly, but indirectly. So for example, we can talk about implicit bias training in the police department. It's not going to have any impact on the explicit racism that's expressed by police officers and police departments throughout this country. It doesn't have any impact on that because we're not screening at the very beginning. We're allowing officers to come in unfettered and unvetted on their racist views. And that's got to end.
Are there any places at all where identification of white nationalist people is used to screen out and prevent the hiring of police?
Don't know. I can't say that for sure. I wouldn't be surprised if there was some effort somewhere, but I wouldn't be shocked if there were no police departments that asked those questions under the guise that it's a First Amendment issue when it's not. It's an employment issue. Are you qualified? So if you have the skills and the ability to do a particular technical job, you're going to be screened for that. Can you have certain computer skills? Do you have certain abilities? If you're a police officer, your job is to defend and protect the public. Do you have the skill to protect every person within the body politic, within the public, every resident? If you don't have that skill or that ability or that wherewithal or that inclination, you're not eligible to be hired. It's very simple.
So you're saying that the defense of that would probably be First Amendment rights?
Not for employment, though. As I said, the Supreme Court has said, that with respect to public employees, the First Amendment rights are curtailed when it comes to not the expression of an idea, when it comes to their employment qualifications. So if you don't have the qualifications, and I see this as a prerequisite, right? It's if you're taking the oath of the Constitution as part of your duty to protect and serve, then obviously that oath means that you would protect everybody equally under the law. And if you're not able to do that, you're not eligible to serve as a police officer in this country.
Okay. We need to do another show ID now, and then we'll come back. And I want to talk about the people who got violent at the Capitol. So 20-second wait. Get it going. And my guest for the show is radical defense attorney Paul Hetznecker. He's the president of the board of the Defenders Association of Philadelphia. He's an adjunct professor in sociology and anthropology at the Criminal Justice Department of Arcadia University. His website is pauljhetznecker.com. And he is just an amazing guy when it comes to defending protesters. He has defended hundreds and hundreds of them, and it's just awesome. So I wanted to ask you now, you've got a lot of people who have been shown on video throwing fire extinguishers at police, smashing windows, breaking things, sitting in the chairs of members of Congress. What about that these people sitting in the chairs? Is that something beyond just trespassing, or is that just another form of trespassing?
It's just trespassing. I'm not bothered by that. That to me means nothing. Those are symbolic reflections of power, and I don't have any problem with that. But trespassing is an appropriate charge, and certainly those who assaulted police officers would be charged appropriately with assault on those police officers. Certainly that's an appropriate charge. Destruction of property, charged with any destruction of property on federal property, would be appropriately charged. And then obviously the question is whether they can be properly identified as the person who committed that offense, and that's up to law enforcement to gather that. So I'm not here to advocate or to assist law enforcement in doing that, because that's not my role as a defense attorney.
No, I'm just trying to get an idea of how they'll be.
Yeah, no, I understand. No, yeah, I'm just saying this to the public. I'm just saying generally to your public. But yes, those would be all appropriate charges: trespass, assault on officers, and destruction of property would all be appropriate.
What about the guy? He was in Pelosi's office sitting in the chair, and he stole an envelope and he left a quarter.
Well, there's theft charges as well. And certainly if he's stealing another person's property, theft would be appropriate.
And it doesn't matter that it's just an envelope. It could be a solid charge. I mean, I know this because there's a history, and I know somebody who worked for the government, used his fax machine for a personal fax, was worth about $10 of faxing a couple pages, and he ended up being federally charged with theft, and it ended up costing over $1 million in legal fees. Karl Rove was behind the prosecution, and so even just if it's hardly anything, you could really make this charge stick if you want to. If the prosecutor, if the federal attorney wants to, they could make that theft charge stick, right?
I don't know all the facts, so I can't comment about the facts. I don't know. All I know of is the picture of him sitting in a chair. But certainly, if he's taken property from another, that's theft. And if it's taken property from the federal government, that's theft from the federal government. So that could be charged. Now, is it de minimis? Is that a smaller basis? Or is that a smaller de minimis crime? It may be. I don't know. But I think that the overall question is are people being charged appropriately for the trespass? And it looks like that's the case. They're being charged appropriately with the trespass and the destruction of property. But I don't know. I have to look at each individual case. But certainly, if, as I said before, if something is taken and it's taken with the intent to deprive then it's theft and it should be charged appropriately.
Okay. Where do you see this thing going in terms of, will there be precedents set here with this?
Well, so it all depends upon the appellate process after convictions are secured. So in order to be a precedent, so if you're talking about a legal precedent as opposed to a political precedent, I think there are two different issues. As far as a legal precedent is concerned, there's already precedents on the books which reflect affirmance of violating federal law when it comes to trespass or destruction of property. In the context of a protest situation, though most of those cases involve progressive movements and people that were charged with protesting or crossing over into a restricted area as a symbolic measure, not an attempt to do anything greater. In other words, not an attempt to stop the election process, not an attempt to destroy property, but just breaching a fence, a secure fence, for the purposes of making a symbolic gesture. That's a very different crime of trespass in its nature. The charge is the same, but the intent may be very different. Here, we have the President of the United States continually trying to undermine an election. And there are election laws that are clearly could be applied to the President of the United States in violating the law with respect to his ongoing effort to undermine a duly constituted election.
Let's talk about these protesters. They went there to disrupt the confirmation of Biden as president.
Right.
So their trespassing was not just incidental trespassing on property, it was trespassing with the intent to disrupt and interfere.
Right.
Is there a different charge for that?
Sedition, and some have been charged with sedition. So, and that's going to be, I think that's going to be the biggest obstacle the government may face. I think one of the things that you have to prove the mens rea in each individual person charged. So there'd have to be some reflection of that mens rea, that mental element, that expression of desire to commit the crime of sedition in social media posts and statements that they made or evidence that they gathered. Simply the presence there probably is not going to be enough to prove that. So I think that's why the government, the Justice Department, has made decisions, individual decisions based on evidence that they have.
And they're going to have so much evidence because these people were so into doing selfies and telling their friends ahead of time and making announcements ahead of time. You know, it's almost
right. Yeah, that's true. That's true.
It's almost like this was the selfie insurrection. It's
yeah. And I think under this naive belief that somehow that they could justify what they were doing because the President of the United States put his imprimatur of power and approval on this action. So, and that leads back to a broader question on whether or not there's going to be any attempt by the Justice Department to charge the President of the United States after he leaves office. And so that's going to be one of the interesting revelatory parts of this process as it unfolds.
How does that work? Well, I don't. That's something I haven't heard. The Justice Department could charge the president after he leaves office. What would they charge him with?
Oh, good question. You know, one can only speculate. I mean, he's making statements that could be connected to the actions of those who are following him that undermined, the protection of the federal building, the Capitol of the United States. So he could be charged with all kinds of crimes related to that. I would much rather see, to be honest with you, I'd much rather see the president be charged with all the other criminal acts that he's been involved in, because this one is just the kind of the icing on the cake in terms of the extent to which he will become a lawless dictator and tyrant. All the underlying things that he's done, the obstruction of justice, the emollients clause, the effort to use his power as president of the United States to undermine the election in Georgia, the efforts that he's tried to use to essentially as the president of the United States and his power to undermine so many other areas, that there needs to be a broader federal investigation into his criminal conduct. And this, to me, the last moment of his presidency, this kind of this extreme expression of his lawlessness, to me is less significant than the pattern and practice of lawlessness that he has reflected throughout his career and throughout his life and as president, which has been reflected in the prior impeachment. It's reflected in the Mueller investigation that essentially punted the ball and said we're not going to recommend that criminal charges be brought. All of these prior investigations, which reflect a president that was willing to wield his power to maintain power, regardless of the law. That to me is much more insidious and much more dangerous than the protest last week in Washington.
Well,
and protest and property destruction, invasion of the Capitol is much more dangerous. That was symbolic. What he did to undermine the law in this country is much more dangerous because he saw himself as above the law. And to obviously many of his followers, they believe he's above the law, and they don't believe in democracy. They believe in dictatorship, and that's what he believes in. And that to me is a much more dangerous effort to undermine our Constitution and U.S. law than anything that happened on January 6th. It's just a manifestation of it. It's the last reflection of a long pattern that this president has been engaged in.
Well, I want to get back though to, I ask you, what about these people who engaged in trespassing with the intent of disrupting the Congress?
Right.
You said the answer was they would be charged with sedition.
And I think some have been, and I'd have to check, Rob, but I think there's been some reports that some have been charged with sedition, or let me qualify this because it's early, or are under investigation and possibly will be charged with sedition. I don't know.
What are the criteria to be charged with sedition?
It's overthrow of the government. Your intent to overthrow the government and taking actions to do so. You can certainly voice your opposition to the government. You can voice and there's a long storied and very dangerous history of the act of sedition or the law itself, because it was used against leftists and progressives in this country. People were prosecuted for sedition simply for speaking out against the government.
I think it was used against Jefferson.
Yep, good point. So so political opponents have used it, as a way to undermine their opposition. So it's a dangerous way, and I'm not advocating that it should be used, because I don't believe it should be used, because I think it's a dangerous effort on the part of the federal government and the prosecutors to undermine the core of what we have in this country, which is dissenting speech. And I think that's where
it makes me think. In my book, Bottom Up Revolution, I talk about how Code Pink, Medea Benjamin, I interviewed her once after she interrupted President Obama when he was giving a talk, and I did an interview with her on how to interrupt a president. And I would imagine then that she could be charged with sedition for that.
Well, no, she couldn't, because there's the Brandenburg case, and there's many other cases on the books that you have to commit an act to be a part of, to be charged with this. The problem, though, is you're correct. Early on in Supreme Court history, where the government charged sedition, the Supreme Court affirmed the acts of sedition and the act itself against leftist labor organizers, anti-war organizers during World War I. So there's a lot of history that demonstrates the very dangerous nature of utilizing that act against people who are opposed to a particular government or particular point of view. So I would caution against using this, because there was threats to use it against many of the Black Lives Matter protesters who were charged with criminal acts this past summer by Attorney General Barr. So there were references, and they declined to do so. And I think it was smarter of them not to do so, just like I don't think it should be done here. What I think should be done is you charge them for the offenses that they've committed. Clearly, you have proof of the acts they committed, and their motive is something different. So if their motive was to disrupt Congress, and their motive was to interfere with the election, then that motive becomes relevant at trial to prove the underlying crimes.
Is that sedition then, if that was their motive?
I have a hard time believing that the Sedition Act is legitimate. I have a hard time, because the way it's been applied, because here's the problem, Rob, the way it's been applied throughout history has been a very, very political one and a very dangerous one. So I would not advocate for charging anyone with sedition. What I would advocate, as I said before, is I would advocate looking very carefully at those who were in power that allowed this event to unfold the way it did. When I say unfold the way it did, there were no barriers around the Capitol. There were very few Capitol Police available to protect the property. It appears that, according to members of Congress, there were other members of Congress that may have conspired or assisted. And we don't know whether that's true or not. So I don't want to say that that's true.
Yeah,
Because that's
but I want to stay with the trespassing, because first I said, the only thing they're going to get charged with, you said the only thing they're going to get charged with is trespassing. And then I asked, well, what about if they tried to impede the finishing of the confirmation of the president?
Well, there are other acts. There are other acts. Still, there are other election acts that they could be charged with in impeding the election of Congress. So I believe there's an act that was passed in the 1870s that goes directly to interfering with an election. There are state laws that involve election fraud. So is this election attempt to undermine the duly constituted government, elected government, or the election process? Yeah, there may be some evidence of that, but not sedition. And I think sedition is a very dangerous thing to charge.
So you would object to sedition charges
I would.
by anybody there?
I would.
Yeah.
Yeah.
And so what I think you're basically saying is sedition is not a law that should even be on the books.
Not in the way in which it's been utilized throughout the history of this country. I would be hard pressed to say that it's anything but a political motivated prosecution.
Where would it? What would be an example?
Well, I don't know. Look, if the military attempted a coup, and that's what frightened people about this, I think, more than anything else, is there's that line of military trained individuals that marched up the Capitol with their hand on each other's soldier in a line on their way to the Capitol entry, and that harkened back to the notion that this was a reflection of the military nature of this, the organized nature of it. And again, I've talked about those allegiances, but if the military had somehow stepped in and said, well, we're going to stop this election process, and that's sedition. That would be a coup, and a coup would certainly be an act of sedition. Now, could members of Congress be charged in the same vein? I'm sure you could create a factual scenario in which would support it. I'm just not advocating it. I don't think it's the right.
You got to be really careful, is what you're saying.
Very careful with it. Be very careful.
So we need a wrap. Final words.
Yeah, I think it's important for all of us to look at the events on January 6th as a wake-up call and a reminder of two things. One is that this democratic process of ours is fragile, but it's strengthened by participation. And we had overwhelming participation this past year, that the institutions of government all must be held accountable, whether it's the military, whether it's the police, whether it's Congress itself, whether it's the President of the United States. The balance of these powerful entities and institutions must all be under the watchful eye of the citizenry. And that means that we need an informed public, not an ignorant public. And unfortunately, we have far too many individuals that have siloed themselves off and cordoned themselves off and only listen to information that they get from, for example, right-wing media that has undermined the truth and reality of what's occurred in our society. Our notion of a shared truth, of a shared reality, has been challenged. And it's been challenged for the last 4 years. It's been challenged since 2000, actually, in real effective ways by powerful media outlets. And we need to reclaim as a citizenry, not just access and transparency and accountability to those powerful institutions, but we need to reclaim truth. We need to reclaim a reality about what's true and what isn't. And that's going to be a very complicated rebuilding process. And we'll hopefully
we're going to wrap. My guest has been radical defense attorney, Paul Hetznecker. He's the president of the board of directors of the Defenders Association of Philadelphia, and his website is pauljhetznecker.com, Hetznecker. Paul, great to have you on again. You're one of my legal heroes. Thank you so much for all you do.
Rob, it's an honor to be on your show, and the work you have done to expose the truth and to portray a truthful news outlet has been phenomenal, and continue to do the work that you do. Really appreciate it, and everyone who listens appreciates it.
Thank you.
Thank you.